All right. Good morning, everybody. Hope you can hear me okay. Excited to get to be with you guys today and talk a little bit of compliance stuff. So exciting stuff. All right. Before we get started, any questions that you guys have compliance related that Jason or I can answer for you?
Not yet.
Okay. Sounds good. Well, what we're going to do is I got a couple things to go through with you. I thought I would highlight a few of the things from the division's newsletter regarding some of the violations that were made by different people. So let's jump into that. So let me share my screen here. Oh, actually, before I do that, let me actually just make sure you guys are aware as well that it looks like Anywhere Corporation, which is who owns the Century 21 system. So Anywhere owns Coldwell Banker, Century 21, Sotheby's, Better Homes and Gardens, and one other one I can't think of right now. But anyway, they are settling on this lawsuit around buyer agent commissions and things. So there's not a whole lot of information at this point, but really ultimately from what I've been able to gather on that so far is what it looks like is just we're going to have to just emphasize with sellers that you don't have to pay a buyer agent commission, which our listing agreement already shows what we would be paying to them. So I feel like we're pretty good that way. And then there's just a couple of other little things, but more information will come on that, and we'll, I'm sure, have a future compliance call with more detail on that. But just kind of a heads up on that. That looks like they are going to settle their lawsuit there. So, all right, I'm going to share.
Sorry, Ross. But so far, it kind of stays the way it is. Is that how it goes?
Yeah, essentially for right now, yeah, nothing's really going to change for how we're handling things and what we're doing.
All right. Thank you.
So anyway, yeah, that makes sense. So
Can I make a comment on this? I was thinking about this the
absolutely.
other day after reading some articles, and I think sometimes in a lot of industries, our industry, healthcare, that sometimes the pendulum has to swing a certain way to find out that it doesn't work very well that way. Buyers, many buyers need the help with that commission being paid to the buyer's agent to be able to afford a home. I mean, we see all these first-time home buyer things. I think if what happens is we see less and less buyer's agents commissions being offered, they're going to see more difficulties in the industry with that. I think it's just the way that kind of a lot of industries go, and we might just see some changes, and we might see that it didn't work very well that way.
Yeah, I would agree, Chris. Thanks. Yeah, for sure. I definitely can see initially out of the gate, you could see some sellers saying, "Well, fine, then yeah, let's not offer a buyer agent commission." And then as their home sits on the market, then they're all of a sudden going to go, "Okay, well, maybe we should offer to pay some." So anyway, yeah, more detail will come on that.
So Russ, my understanding when I always went to a listing appointment is we always shared that information with them that they don't have to pay a buyer agent commission.
Correct.
It's just recommended. So I don't really understand why everybody is well, but maybe we'll talk about that later.
No, I'm in agreement with you. To me, I'm like, this feels like kind of like really I think the problem was is there probably were agents going in and saying to sellers, you have to do this. And clearly enough for there to be a class action lawsuit and for Anywhere to come out and say, okay, we're going to settle. And it's like $85 million. Like it's not a small settlement to settle this thing. So, and one of the things that I've learned since I've been the principal broker and dealing with a couple of lawsuits is typically if there's a settlement, it's based on how likely do you think you are to win. And if you what percentage you feel like you are going to win, or lose, I guess I should say, is the percentage of what you should pay out, kind of a thing. And I don't know if that makes sense, but ultimately, I think this was like $1 billion lawsuits, and they're offering 85 million, which is kind of saying, hey, there's a chance we could lose this if it goes all the way, and so we'll just settle to get out of it and pay $85 million, which is kind of crazy. So anyway, all right, so I'm going to jump into to this. So I'm going to share my screen with you so that you can see this real estate newsletter from the division. And what you're looking at here then is just the part that is about real estate. And so there's a few of these in here, some of them not a huge deal, not something we need to worry too much. But as I read through them, I thought, oh, it should be a good just reminder to talk about some of these things. So this first one was this agent in Sandy, that she admitted that she advertised the availability of real estate in a false or misleading or deceptive manner. And what happened on this is she was going to be listing a property. The owner was deceased. And so she started to market and advertise the property before there was a personal representative for the estate that was assigned, which there's another one later on, which is why I thought, well, man, we probably should talk about that. So sometimes what will happen is you go out to go get a listing, and maybe you find out that it was in the name of somebody who's deceased. Now, if it was a joint tenancy situation, then as soon as the one dies, the other automatically becomes the owner. So you'll still need a death certificate to show that, but you would be okay going ahead and listing that property. Where you could potentially run into a scenario of this is maybe both the parents have passed away and the property is in their names, and they're saying, oh yeah, we're going to get it, and I'm going to be the representative. Well, until they are the personal representative, you actually can't list the property or do any marketing on it. And so this agent was fined $1,000 and has to complete 3 hours of CE as well.
Russ,
The
what
next
happens
one,
when it's in an estate, so it's like a trust, where it lists the trust on the in the documents and not really a person.
yeah, so as long as it's in a trust, that's great, because we just need a copy of the trust showing who can sign on behalf of that trust. And then typically within the trust, it shows successor trustees, that if for some reason, so it was in a husband and a wife's name, or the trust, the trust, and had the husband and then the wife as the trustees, but then it'll show successor trustees. So that's the good thing about it being in a trust, is unless all of the trustees have passed away or gone or something, you're going to be okay, because you would be able to continue to work with it based on whoever the trustees are. So hopefully that makes sense what I'm saying.
Thank you.
Russ, I have a
Yes.
question. I'm going to be
Okay.
getting a listing here soon that the mother's still alive, but the daughter has the power of attorney, and so she's going to be signing. Is that okay?
Well, so the property's in the mother's name,
Yes, but she's
but
given
she
her
has a
kids
power of
power of
attorney.
attorney.
And is the power of attorney, I mean, is the mom still competent, or why does she have a power of attorney?
She just doesn't want to deal with it.
Okay, so what I would recommend on that is have your title company have North Star take a look at that to see, make sure that you have everything that will work for that. And why I say that is because sometimes the power of attorney covers everything but real estate. And so
Okay.
you just got to make sure the power of attorney is worded that they have the ability to sell real estate on behalf of them as
So
well.
do I
So
need to
should be
ask
fine.
for that, like before I
Yes.
list it?
I would, yes.
Yeah.
Yes, for sure.
Okay, perfect.
Cool.
Okay,
Great
thank
question. All right.
Ron.
This next one. Yes.
Sorry.
Go ahead, Tracy. No, you're
I'm
good.
going through this at this moment with a client, and I just kind of wanted to make sure you really work with the title company on what they specifically need. Like, my client is in another state. Well, different states have different power of attorneys or whatever. And what happened to mine is, yeah, the mother wasn't incapacitated, but she didn't want to deal with it. But then she became really sick and now is incapacitated. So at this point, they did not mark the section where the power of attorney can create a trust. And so if she passes away, the power of attorney is no good and has been a huge learning experience. So make sure while they're competent that she makes sure that it's all of that. And if you're working with a trust company or a title company right away, then they'll probably tell you that. Although it kind of took us a month to get all of this down. And since then she got incapacitated. So she's be going to hospice, and it's kind of a prayer situation now that everything is settled before probate, before it has to go to probate. So
Yeah.
Well, thank you. That's good to
you're
know.
welcome.
Perfect. Yeah, thanks, Tracy. Okay, excellent. So the next one here, this one was an agent out in Stansbury, and he admitted to representing a buyer in a transaction that he failed to inform the seller's agent that the buyer did not deposit earnest money with the brokerage. So I think Jason talked about that last week a little bit on this, but what ended up happening is in this, if you read through it, is the agent said that he had received the earnest money and deposited it. And then when the deal fell through, the seller said, okay, well, we're going to take the earnest money for liquidated damages. And the agent then said, well, actually, we never collected earnest money. So this one, the agent had to pay a penalty of $2,000 for that. So again, just a reminder, if for whatever reason you don't collect the earnest money, make sure that you are informing everybody as to what has happened, that you didn't get the earnest money within the time frame, do an addendum and extend out that, but just make sure everybody's aware of what's going on.
So Rosa, a question in here. The agent was fined $2,000. What happened to the seller and their liquidated damages?
Well, it doesn't tell us what ended up happening there, but ultimately what would have to happen is the seller would have to go after the buyer, probably take them to small claims court to try to collect that.
Is there a possibility that then they name the agent as well?
It's possible, sure. Yeah, I mean, it's always possible, but typically in a small claims court scenario like that, it would really probably kind of have to be more of the seller has the recourse to the buyer for that, and then the buyer could then turn around and come back potentially, I guess, to the agent. But it really just depends on, what was the agent doing? Did they tell the buyer they didn't need to send it? Like, we don't know all of that detail, but yeah, I guess it's always possible. And really, I guess I always just come back to when you ask that, like, is it possible? I always go, somebody sued McDonald's because they spilled hot coffee on themselves. So, anything's possible. So anyway.
Okay, thanks.
All right. Yep, you're welcome. Okay, this one is the agent admitted that she entered into a limited agency consent agreement to represent both parties in a transaction. And then after entering into the limited agency consent agreement, she loaned one of the parties to the transaction money. So therefore, became a member of the company. So now, because she's now a part of the company, so in essence, she was giving them money to buy into ownership of this company. So now she is a principal in the transaction, but she continued to act as a limited agent. So a reminder again, if you are a principal in the transaction, you cannot act as a limited agent in that scenario, because you can't be limited when you're now a principal to the transaction. So on this one, she had to pay a $4,000 and complete 3 hours of continuing education in addition to the continuing education she already has to do. So again, just reminder on that one, can't be a principal in a transaction that you can't be a limited agency agent in a transaction that you are a principal of the transaction as well. And then this one is similar to what we had talked about before. So this was an agent down in Cedar City, entered into an exclusive listing agreement with a client and agreed to represent her in the sale of the home. The home was the residence of both the client and the client's deceased spouse, but the title to the home was held solely by the deceased spouse who died without a will. So in the MLS listing, she disclosed that probate of the estate would be finalized prior to the sale. The client then filed documents in probate court to be appointed as the personal representative of her deceased spouse's estate, sent a text message to terminate her listing agreement. And so the point on this is Utah Administrative Code says that a licensee cannot advertise or sell property without written consent of the owner. And because she couldn't obtain the consent of the owner until a personal representative was appointed, she then admitted that her actions were in violation. So on this one, she ended up having to pay $1,000 fine and do again 3 hours of continuing ed in addition to her other 18. So again, just making sure you have the right signatures from people before you go out and market their property is a big deal. Of even though, and really, I guess that ties into something that I got from the MLS this week as well, is that we can't go advertise something that is either not true or that you don't have permission from. So in this case, we're talking about the permission from. But I got an email this week regarding one of an agent within our company and their listing, and it's saying that they had somebody had filed an anonymous complaint saying that they were advertising the property to have the incorrect number of bedrooms. Well, our agent said, well, I did put down in the remarks that the one area could easily be converted back to the bedroom. So the agent was saying, you know, I disclosed that it could be put back to being a bedroom. And I can't remember if they had taken a door out or part of a wall or something. But the agent had advertised it as saying, I think it was 4 bedrooms, but the 4th bedroom, and they put in the remarks, 4th bedroom's missing this or that, but it could be converted back. And they responded back to the MLS and said, hey, I did disclose, it says in the remarks that it's not currently being used as a bedroom, but could be. And the MLS's response to that was, you need to fix it to say how many bedrooms there are. And then in the remarks, you could put down, you could easily convert it back to a 4th bedroom. So that one's a little bit hard because you would feel like, well, you know, anybody before they went and looked at the property should notice and see that it doesn't have it. But the MLS is saying, no, you have to advertise what you really actually have. So just kind of keep that in mind in terms of your advertising and things, that you have to present a true picture. Yeah, go ahead.
I have a question back with regards to someone who has passed away. I was representing a buyer, and when we got the title report back, there was actually 3 people on the title, and it was 2 of the people had passed away, but they were not joint tenants. They were tenants in common that we found out. And so a probate needed to be done. And I really, so I wonder, the listing agent said, you know, we'll do probate really quick if your buyer wants to continue, but he kind of almost was a little bit forceful in, you can do whatever you want. We can even, you know, take the listing down until it's done. But if your buyer wants this, we'll just put it up for more money later after. But so in that situation, what should the seller's agent have done? It worked out okay. We were able to get through it and hang through the probate that they did because no one contested it. But what, if I was on the seller side, what should I have done if I had found that out?
Yeah, so really, well, so they didn't find the listing agent didn't find out until after you were under contract?
That is correct.
Or they knew before? Okay.
Oh, they found out after. They knew that there was other people on, but he just said, they were, in the beginning, that he said that they were joint tenants.
Yeah.
And they were tenants in common.
Okay. So, I mean, it sounds to me like really probably should have researched it a little bit more, I guess, to make sure. And so I guess that's probably the good point on this is just anytime you have a client tell you that somebody's passed away, probably your first thing to look at is, was it in joint tenancy or tenants in common? Probably 99% of the time it is going to be joint tenancy. So in which case you're fine. But I would say for sure you want to check it. Once you are under contract on it and finding out, I mean, probably what they did was the best solution potentially for that. But yeah, I would say as soon as you find out if it was still listed and you found out, you should take it down the listing until you get all of that worked out. So I don't know. I see you nodding your head, Jason. Were you going to say something?
Yeah, I agree with you. I do think though that tenants in common, if you don't have those signatures or it's still in probate, you actually don't have a valid listing agreement. You cannot, they could not sell that. So in that particular case, I think they would be similar to this fine where they are advertising something they cannot do. So even if it goes under contract, I mean, the reality is, let's say that it does go under contract and the probate doesn't work out or somebody contests it, that contract's not valid. It's not, you don't have the right to sell that property with tenants in common. So really, Chris, what I would say is that listing agent should have pulled it off, got that solved, then was their representative, because in my mind, they did exactly what's happening here. They're advertising something they didn't have the legal right to advertise.
Great, thank you. That's what I was wondering.
Yeah, I think just the challenge though, from what you were saying, Chris, though, was that they said to you, we can do that, but if we do, then we're going to put it back on for more money or something, right?
Yeah, that's what they said. They, in fact,
Yeah.
in the beginning, they didn't even say, there was only one signature, and I went back to them and I said, hold it, there's 3 people on title, but there's only one person who has signed, you know, the acceptance. And that's when he said, oh, well, they're tenants and, you know, tenants.
Yeah,
So that's
yeah.
why I was like, what?
Yeah. So yeah, I think, yeah, no question that the right way to handle it is to pull it off, do all that kind of stuff. But I think based on how your story was, I think it was fine what you did, meaning if they were willing to say, well, let us get it worked out. And then, but yeah, there would have been nothing to stop them from just saying, we don't have a valid contract. Therefore this deal's canceled and, you know, all
Yeah,
of
I don't
that.
think
So
the problem was on your side, Chris. I mean, the buyer
Yeah.
side's not the one that's the problem. It would have been the listing agent. So if somebody would have filed a complaint against the listing agent based off of what they said and did for your transaction, they would have been in the newsletter too. So I don't think
yep,
it's,
they get the same fine.
yeah, they get the same fine because they're not doing it right as far as the buyer and how you guys handled it. Like you guys are just saying, yeah, sure, we'll hang out, we'll let you get it done. But basically, if you want to look at it in the simplest forms, you talk to a seller, there's not a listing agreement in place, and you say, we'll wait until you get your listing agreement in place in a month, and then we'll buy it from you. That's pretty much how it came about.
Thank you. That's helpful.
Perfect. All right, next one. So the next one is this agent down in Washington County, or I guess Washington, not which Washington is in Washington County, but he admitted that he failed to obtain written agency from either party when representing both the buyer and the seller of a new home to be constructed. So he didn't get agency from either party. And then in addition to that, he failed to get the limited agency consent agreement. So Luz is on the call right now, and she actually had a client this week that she was writing an offer with that was trying to tell her he shouldn't have to sign an agency agreement. And so just kind of so you know, Luz, we got it worked out, so you're good. But had you not, you could have fallen into this same kind of a thing, which is why we did what we did with him, which this agent ended up getting a $2,000 fine for that scenario. Now, was it 2,000 instead of 1,000 because they didn't get it from either party or limited agency? But just keep in mind that you're going to from time to time have clients that want to tell you, I don't have to sign that, or wherever I came from, they don't do that. Well, we are required by the Division of Real Estate that we get a written agency from our clients. So just a reminder on that. And then I think I had one more. Maybe that was it. Nope, that was it. So anyway, any other thoughts, questions on anything? Okay. Well, thank you all for jumping on and being with us today for this compliance call. As always, if you have other questions, let us know. You know, our job is to try to help protect you and the company and make sure that we don't end up in the newsletter. That's our goal, is not to be on the news and not to be in the newsletter is what I hope for in my life. Anyway, okay, thanks for being here, guys.
Thanks, Russ.
Thank you,
Always
thank
helpful.
you, thank you.
See ya.
Thank you.